Morning everyone. Welcome to the Aitken Partners July Business Law Breakfast series. It's objecting to property rating valuations, a couple of housekeeping matters. The toilets are out there on the left of the lift lobby, and feel free to get a coffee if you want it. We've got three speakers we'll talk about you in a moment, and we'll send you some slides after today about the format of today's discussion. Today's discussion, as I said, is about the property rating valuations. We're very lucky to have three people who have experience in this rather niche field, all from different perspectives. We've got Ebony Roach from our firm here, we've got Will Pearce from Human Habitats, we've got Nicodimou from Fitzroys. Ebony is an associate of our property team here, and she's worked on compulsory acquisitions and rating valuations, or challenges to rating valuations, for the last 2 or 3 years. The rating valuation is very much dependent on the legislation, in particular the Valuation of Land Act. Ebony eats, drinks and sleeps the Valuation of Land Act, so she knows it very well. And she's one of the few lawyers, I suspect, in Melbourne that does, because, as I said, it's really a niche field. In today's climate, where you have escalating property prices, or you've had escalating property prices, that has a consequence, of course, of the councils and the authorities then, off the back of that, sticking up the land tax, sticking up the rates and all that. So it's not surprising that there are challenges being made to the ratings based upon what's called the site value, which Chris will talk about to you in a moment. Will Pearce is a director at Human Habitats, which is Will's a town planner, and Human Habitats is a strategic planning firm about land and other planning issues. I've had a relatively long-standing Zoom relationship with Will now for some time. We had a case on last year, and let me say, Will gave some really on-the-point planning advice, and so far as this was in VCAT, and so far as the VCAT proceeding was concerned, he knew what our clients needed when he was doing his planning advice. So he was really switched on about what advice he was providing to our clients, which was very, very helpful so far as the case was concerned. Chris Nicodimou is the Division Director of Valuations and Advisory with Fitzroys. Fitzroys, you probably all know, is a property, what are they called? Real estate advisory firm based here in the city. Chris and I have worked on rating objections now for the last 3 or 4 years. Site value is critical in that analysis, and if there's what Chris doesn't know about assessing site values of property, it's not worth knowing. So I think, Ebony, you're going to be the first speaker, so I'll hand over to Ebony.
Thank you, and thank you all for joining us this morning. So yes, we're going to be speaking about objecting to property rating valuations. Speakers? So valuations for council rates and land tax notices are made annually and are made in accordance with the Valuation of Land Act 1960, as Andrew pointed out. If you disagree with the value of your property assigned to these notices, you can lodge an objection with the relevant rating authority. Today I'm going to briefly outline the process of how to object to a property rating valuation, which is regulated under Division 3 of the Act. So who may object? A person aggrieved by a valuation of any land may object to that valuation. Under the Act, an aggrieved person is someone who is given a notice or valuation notice, or someone who is liable to pay the relevant rate or tax in respect to that land. An objection must be in writing and may be made on any one or more of the following grounds. So Section 17 of the Act identifies 7 different grounds for objection. I won't read them all, and I'm sorry if that's hard to read, but some of the most common grounds include that the valuation is too high or too low, that the apportionment of the valuation is not correct, and I'll get into a little bit more detail about that later, or even that the area, dimensions or description of land included in the property code allocated to the land is actually incorrect. In order to determine which grounds may apply and the merit of any objection you may have, It is recommended that you engage a valuer or a valuer advocate such as Chris to undertake a valuation and assist you with this process. The time to object. So an objection must be lodged within 2 months after the notice of valuation or assessment is received. Alternatively, if you are an occupant, you have 4 months to lodge an objection. Exchange of information. So this is what we refer to it as a Section 20 exchange of information. And under the Act, there is an opportunity for an objector to exchange information with the valuer has been referred the objection. Within 1 month after lodging objection, the valuer must give the objector prescribed information. So what is prescribed information? It's defined under the Valuation Land Regulations 2014, and it includes things such as the address, the reference number, details of the land and improvements, a description of the valuation approach, including any sales that the valuer has relied upon, and also a response to the information contained in the objection if that's appropriate. So within 1 month after receiving the prescribed information, an objector may lodge a written submission. It is important to note though that this Section 20 exchange of information only applies if one of the grounds for the objection is that the valuation is too high or too low. The value it also only applies if the value assigned is not less than the prescribed amount, which is defined in the regulations. Chris can probably speak to more detail if you have any questions about that, but so you know, it's a net annual value of 120k, site value of 1.5 mil, or a capital improved value of 2 million. So the next step in the objection process is the determination of the objection. The valuation authority must refer the objection to the valuer who made the valuation. The valuer must provide the objector with a reasonable opportunity to discuss. However, as this Act likes to point out, there are some exemptions. So if the exchange of information section did apply, the valuer is not required to provide that reasonable opportunity to discuss unless the objector has made a submission. So within 4 months after receiving the objection, the valuer is then to provide written notice of their decision. So they're either going to disallow the objection or they're going to recommend that an adjustment is justified to the Valuer General. Within 2 to 4 months, the Valuer General may then disallow in part or in full the adjustment or confirm the adjustment, and then they'll need to provide notice to the relevant parties. So if an objector is dissatisfied with the decision of the valuer or the Valuer General, then an objector may apply to VCAT for a review of the decision. So this is governed under Division 4 of the Act, and an application must be made within 30 days after receiving the notice of decision. However, if a valuer or a Valuer General did not provide any notice of a decision, then it is deemed under the Act to be disallowed. So then the objector has 9 months after the objection is lodged to make an application to VCAT, or alternatively, 2 months after the Valuer General has received the recommendation. Now, grounds of review, if you are applying to VCAT and you are saying that the value is too high or too low, you do need to state what you contend the site value to be. So, or the other value. Chris will be able to assist with that process, or any valuer as a valuer advocate, and Chris will be able to talk about what the role of a valuer advocate does soon. But you will need to state what contend your site value and the powers of review. So what the tribunal can do is they can order, confirm, increase, reduce, or otherwise amend any valuation. So they do have quite a broad power, and they can make any other order it thinks fit. So if you haven't already done so, this is the stage where I would highly recommend getting some legal advice to assist you with the application process and also assist you in formulating your claim and engaging relevant experts to support your claim. So I'll just briefly talk about engaging experts. So if you are the objector and you are the applicant in VCAT, you need to submit evidence to support your objection. So we recommend engaging experts such as valuers and planners to file a report in the tribunal. An expert is required to provide an impartial opinion based on their area of expertise, and Schedule 3 of the VCAT Act sets out the powers that the tribunal has in relation to expert witnesses and reports. Now, it really is recommended and it really is important to brief experts properly. So that means also ensuring that the expert has a copy of the relevant VCAT practice note, because this sets out the expert's obligations and their requirements for an expert report. For an example, an expert has an obligation and has the paramount duty to the tribunal and not to the party retaining the expert, They also have an overriding duty to assist the tribunal on matters relevant to their area of expertise, and the expert cannot be an advocate for a party to the proceeding. So for an example, and Chris will go into this into more detail, but if you did retain Chris during the objection process, you would need to retain another independent valuer during the application to VCAT. Now, before I pass you on to Chris here on some more exciting stuff and not just the valuation of Land Act, I will talk about the recent Red Dot decision made in VCAT only a couple of weeks ago on the 11th of July. So a bit of background about this case. So Mr. Bolter applied to VCAT for a review of the decision under Section 22 of the Valuation of Land Act. Now, in this case, there were two occupants of the property, therefore there were two separate assessments issued. The first assessment related to the storage units on the property, and the second assessment related to the lodge, dwelling and all other improvements on the property. It's important to note here that only assessment number 1 for the storage units was actually under review, so Mr. Bolter didn't review the second assessment. So the tribunal found that the occupancy formed part of a larger property for the purposes of Section 2(3) of the Act, and therefore the valuations must be assessed on an apportionment basis, having regard to the valuation of the larger property as a whole. So this required the tribunal to consider all the improvements across both occupancies on the subject property for the purpose of finding the correct valuation relating to the first assessment. So Mr. Bolter contended that the return valuations were too high and the wrong Australian Valuation Property Classification Code was incorrect. So Mr. Bolter was actually self-represented and he did not call any evidence to support his valuation. The valuation authority relied on expert valuation evidence at the hearing, and they contended higher valuations than the return valuations. So there are a few issues addressed in this matter, including commentary about mass valuations, transparency of calculations, including the return valuations, the role as an expert tribunal, the independence of an expert, and the fact that the tribunal may inform itself as it thinks fit. So I'm just going to make the following comments in relation to those issues. The tribunal noted that the valuation is actually not an outcome of a mass process. However, the tribunal recognised that there are constraints in delivering valuations of large volumes of properties across the state on an annual basis. However, once a valuation does reach an objection process, it's a different stage, and the Act contains appropriate provisions for review of the valuation, and importantly, effective communication with the objector. So the tribunal may need to inform itself about the basis which have underpinned the return valuation to validate its considerations. And although the tribunal is unable to arrive at a valuation of its own, it may ultimately disagree with aspects or components that make up the valuations under review. Appropriate adjustments can be made, provided those adjustments are grounded in evidence. So the tribunal accepted that the VGV's expert was independent. However, they commented, which might be important for some valuers to note, that they would have given greater weight to his evidence had he confirmed that he had undertaken all of the valuation analysis himself in the first instance. So in this case, the expert actually relied upon sales provided by the original valuer. So it is a form of peer review evidence. However, the tribunal commented that they probably would have been given greater weight if he had conducted the analysis himself. The tribunal also called for further information from the VGV about the return valuation, which included conclusions reached by the contract valuer in disallowing the objection. Ultimately, the tribunal found that the correct valuations were actually higher than the returned values, but not as high as the valuation authority contended in the proceeding. The tribunal did, however, find that the code should be amended as submitted by Mr. Bolter, And look, amongst other things, this case really flags the importance of retaining experts such as lawyers and valuers to assist with the objection process. In the absence of any contradictory evidence relied upon by Mr Bolter, the VGV was the only expert called to give evidence. At the hearing, the tribunal was required to give appropriate weight to any evidence that was before them. Full questions are at the end.
No, well, just one.
Okay.
Does that mean the original site valuation, you challenge it, you go to VCAT, you're lower, the tribunal can actually end up with a higher valuation of what was originally contended to be worse off?
That's
Is that a
correct.
risk?
That is a risk, and that's why it is important to engage those experts. I'm going to pass it on to Chris, and we can take questions at the end.
Good morning to all guests here and online, and thank you to Aitken Partners for hosting this morning, and Andrew for the introduction. I urged Ebony and Andrew Blogg to do this presentation early morning, so we caught you all bright-eyed and bushy-tailed, at least here in the room for now, and I'll give an update status of that at the end of my presentation. In my presentation this morning, I will avoid jargon, and I will in some areas present a simplified message to emphasise key points. In dealing with the topic on the screen, I've broken the presentation down into the following sections. Oops, wrong direction. First, I want to share with you an important document, then highlight some key points about rating valuations, discuss the site value actually in the rating context, and I could not leave today without imparting my experience in the art of objections and the role of the advocate valuer. So firstly, this document is a very important document. It's the Valuation and Rates Notice. The moment you receive this document, the clock starts ticking. In fact, you only have 60 days from the date of issue to lodge an objection. The notice also has the date of valuation, and also there are three values on the notice. Those three values are the net annual value, which for residential property is 5% of the capital improved value. For commercial property, it is approximately the net rent. Then there is the site value, which is the value of the land. And capital improved value is the total market value of the land plus buildings and improvements. This document is issued every year around August to September, depending on the council, and is used for rating purposes. Now I want to talk to you about these valuations on the rating notice. Many of you would have heard the words, I'm sure, valuations is not an exact science. These words have found their way into many legal and court decisions. These decisions have gone further to say that for valuers, and I'm reading off the left-hand side, the right-hand side there, the experience of professional judgment is often intuitive and based on experience over time or an intrinsic knowledge of particular factors affecting the location or sector of the property market. The experience of professional judgment forms an important part of dealing with an objection, and many objections are resolved in this way without there being a detailed explanation of the particular factors that may have led to a particular refinement or adjustment being made. So what I want to emphasise to you is site value, net annual value and capital approved value are all opinions prepared by a property valuer. These valuations are prepared by contract valuers appointed by the Valuer General of Victoria, who took over the system in 2018. Valuations are updated annually in the council rates notice, and these valuations can be challenged. Let me now consider site value, which has probably the most impact of the three values to a property owner. Site value is used to assess the land tax. The definition of site value basically encompasses the three principles that I've underlined in the slide. That is, that an estate in fee simple unencumbered. It's to consider sale on such reasonable terms and conditions, and importantly, it is assuming that the improvements had not been made on the land. Effectively, this is a bare land concept, but ironically, works and buildings that devalue the bare land must be included. I'll come back to this shortly. So when assessing the value of the bare land, you must also assume that the land is valued according to its highest and best use. Therefore, there are two critical issues when assessing site value. First is the highest and best use of the land, and the second is to disregard the improvements on the land. So site value must be assessed according to its highest and best use, and the concept of highest and best use is outlined well in a number of court decisions. Highest and best use represents the most profitable potential use, having regard to both planning and like controls. The land, when the land is sold, the market value values the land at its highest and best use, and the seller will seek to achieve the highest price for the land. So highest and best use has a very strong connection to planning controls. However, valuers are not planners, and any layperson's knowledge of planning is dangerous. This is where expert advice from a skilled planner like William Pearce is critical when it comes to assessing the highest and best use and running a successful objection. Now, going back to my earlier statement that site value must be a bare land assessment which excludes all improvements. Improvements are defined in the Valuation of Land Act as all work done for the benefit of the land, work done or material used that increases the value of the land. So site value therefore excludes things that enhance its value. Conversely, works to the land that devalue it must be included, e.g. heritage buildings or even contamination. In these cases, the site value must be adjusted down to take account of this impact. This is where valuation can become quite complex. There are currently matters that these particular matters are still currently before the court in some new issues that have arisen since the state government repealed a couple of sections in the Valuation of Land Act back in 2019. And the team presenting here today have had some recent successes in this complex area. Now, I think it is important that I explain the mastered art of objection. Because if you do not object, there will not be any review in values. And after acting in some 800 objections and over 300 VCAT representations, I think I can offer some insights into this area. And this is how I usually start. And if everyone in the room can please repeat after me. I object. Very good. An objection can be lodged to any or all three of the values in the rates notice. An objection can only be lodged to the site value in the land tax notice. The objection must be reviewed with the contract valuer who did the valuation. The contract value should be held to account to explain how they derived the value. Objections must be resolved within 9 months of the objection date, and if you are not happy with the review outcome, you can appeal to VCAT, subject to timeframes. Now, VCAT is a two-part process involving mediation and hearing. In a VCAT mediation, the Valuer General runs the objection for their side, and they use Land Use Victoria legal team, which is their in-house legal representatives. The Valuer General will generally only agree to an adjustment for errors, but not opinions. In a hearing, however, the tribunal will determine the values after hearing the evidence from both parties. Typically, you would only appeal to VCAT if there was an opportunity to significantly reduce the values or if there are untested principles. Now, Ebony discussed the role of advocate and expert earlier. Now, I wanted to give you some thoughts on how I run objections in my role as advocate valuer. So the role of the advocate valuer is to advise the client of their options so they decide. Act to review and reduce each of the three values whilst acting within the professional standards. Investigate development site sales around the date of valuation. Understand and analyse each sale. Speak to the parties of the sale. Understand the buyer's view of the highest and best use of the land, considering the planning matters, and break down the analysis to a dollars per square metre of land or gross floor area. Now, it's also important to analyse the subject property, or the objection property, the same way you have analysed the sales evidence. That is, you've got to consider what the highest and best use is, and also consider the development potential GFA of the land. And of course, apply valuers' experience, intuition for factors of comparability between the sales evidence and the subject property to assess the value of the property. This may not always lead to conclusions to object, of course. A skilled advocate valuer will manage the objection process, keep the client informed at all times, provide an informed basis of whether to appeal to VCAT or not, bring together the most experienced team to maximise the opportunity of success and minimise risk. Work with the team, including the legal people and the experts, to ensure the valuation methodology and all valuation outcomes are considered. Work to ensure the benefit to cost ratio to owners is maximised. Clients will always respect an informed and honest view. So, in summary, I hope you have taken away today the following key points. Keep an eye out for those rate notices. Valuations are an opinion and can be challenged. Site value is subject to interpretation. Objections need to be strategically run and get the right team of experts to get successful outcomes. Thank you and good morning. And amazing, yes, you all still look bright-eyed and bushy-tailed. Hand over to Bill.
Thank you everyone for getting up nice and early to be here, and thank you to Aitken Partners for giving me the opportunity to present and talk about what I'd love to do, which is town planning every day, or 5 days a week. My name's Will Pearce. I'm a director at Human Habitats and one of the owners of Human Habitats, which is a planning, urban design and landscape architecture business based in Melbourne, and now we also have an office in Brisbane as well. I've been practicing as a consultant town planner for 15 years, and I've had the opportunity to work on a number of really exciting projects across Melbourne and in southeast Queensland. As I mentioned, Human Habitats is a advisory firm. We have 30 property experts, urban designers, town planners and landscape architects. I personally work at Human Habitats with clients across southeast Queensland and in Melbourne. And we use our team to provide advice to clients about primarily the development potential of their properties. We primarily act as advocates working with councils and state government authorities in their interests with a view to try and optimise our clients' land holdings. And that's important because we play a very different role in land tax valuation objections. We play the role of an expert, and our duty there is usually to a tribunal or a court and not to our clients. So I think it's first important that I explain our approach in terms of how we act for our clients. When we look at their land holdings, we typically break down I guess the development potential of our clients' sites into a series of scenarios. This isn't always the case, that we can break it down into multiple scenarios, because sometimes and increasingly we might have mandatory height controls which don't provide an opportunity for uplift. But like this example in Geelong, which from a planning perspective is in a state of flux at the moment, we break it down into an optimal development scenario, a defendable development scenario, and something that's probably more conservative for our clients to really understand the different levels of risk depending on what their risk appetite is. We then typically talk to our clients and we listen to them and we try and understand what their objectives are for the site and also what their risk appetite is, particularly at the acquisition stage. And typically the clients that we enjoy working with operate in this part of the spectrum, the defendable or optimum development scenario. And they're usually aspiring to achieve an optimal outcome for their sites. And when they do that, we encourage them to invest in a really good team, usually a high quality architect and quality architecture and design, and increasingly landscape architecture as well. We encourage them to think about placemaking strategies, things that can be put in place to make the final outcome for the community better. We encourage them to think about their environmental footprint and how they can design their buildings in a way that responds well to the environment. And we also ask them to think about what public benefits they could unlock through a development. Things like creating cross-block connections or new public spaces within their development without obviously compromising the ultimate yield. In helping our clients achieve their goals for their sites, we have to look at a whole range of factors. We have to look at site-specific factors, which is something that is common to both exercises when we're wearing the hat of an expert, particularly in site valuation objections. Yeah, we look at planning scheme provisions, land area, the interfaces of the site, the scale of buildings around the site at the time of the valuation, and we look at the political context as well. These are things that don't change whether we're advising a client in the role of an advocate or when we're advising a client in the role of an expert. There are also some project-specific factors which, when we're acting as an advocate, we have the benefit of understanding what the client objectives are, what type of architect is involved, and other benefits that our clients acquire as part of a project. These are things that are very difficult to think about in the case of a theoretical assessment of land value. And what that means, from my perspective, in terms of how we approach the objection process for the purpose of land valuations, is that we naturally need to be more conservative because we don't have as much information about how a site might be optimised. You might be asking yourself, well, why has planning popped up and is increasingly becoming important in these land valuation objections? Using my crystal ball, I look back at the last 8 years of the Labor government. We've never seen so much change in planning rules in Victoria. These are just 4 examples of major planning reforms in some of the most dense and complex areas in Victoria. The one that is the subject of a lot of these objections is obviously the Hoddle Grid and South Bank, where soon after the Labor government, our current Labor government came in, they brought in the Planning Scheme Amendment C270 as the permanent controls for the Hoddle Grid and South Bank. These are major controls that mandate certain setbacks, even have plot ratios and alike. And as a result, the development potential of many sites across the CBD and South Bank has been substantially reduced, particularly for smaller sites, small, narrow sites. And we'll get to that a little bit more later on. More recently, in the Melbourne CBD, we've seen some urban design principles be brought in. And those types of planning rules can also have significant impacts on the potential to develop sites, particularly small sites. And in particular, in this amendment here, there's now a prohibition on podium car parking when it is not sleeved by some sort of active use, which again is really problematic for small sites because if you've got a small property, having above ground car parking, the ability to sleeve that and provide an efficient car parking layout is really limited. These are the types of details that need to be looked at and can significantly change the theoretical value of land. We've also, and are continuing to see, major planning changes happen throughout the Fisherman's Bend precinct, and now also Central Geelong, although we're still waiting on a decision from our new planning minister on what those final planning controls are going to look like. And in the most part, probably with the exception of Central Geelong, these planning scheme amendments reduce the development potential of many land holdings. Say that Central Geelong, there's a bit of adjustment, so there were some areas of the city where there's actually improved potential value, but other parts, for instance, we've looked at sites that have planning permits that are pre the interim controls which exist over Central Geelong, where the development potential is actually half of what it was. So in terms of our approach when we're looking at assessments of land tax rating objections, we have to take a different approach to what we normally would when we're acting for developer clients. We consider site-specific matters only, and we start with a conservative view of the development potential, but also recognising both the defendable and more aggressive planning positions for sites. We also like to look at issues of viability when it comes to the size of sites, things like what I was talking about before with the ability to sleeve podium car parking and alike. And I've got a case study here because planning's complex, and just pointing to areas in the planning scheme, it's going to make it difficult for the non-planners in the room to understand. And a few people in the room actually worked on this matter. This is 520 Collins Street, which is actually, believe it or not, a heritage listed commercial office building on Collins Street. But as Chris pointed out, when we're looking at this theoretical value, I need to imagine that this building is not actually there, we can't take that into account. So the first thing I look at when I'm thinking about the theoretical value of a site like this is we look at the planning controls, and what they say is that typically speaking, they want a podium tower type development under DDO 10, between a 20 and 40 metre street wall or podium, and then above that you need to set back on all sides a minimum of 5 metres. And actually, if you go above sort of 80 metres in height, there's actually a sort of more graduation of setbacks above that. And what this essentially encourages is development on large sites, but narrow, skinny sites like 520 Collins Street, incredibly difficult to develop under C270. I can't remember how wide it is, but it was in the order of 15 metres. So a 5 metre setback on both sides above the podium, it's going to mean a very, very small floor plate above that. Fortunately though, up to 80 metres, you can actually put under DDO 10, Design and Development Overlay 10, you can put a wall on one boundary, which makes floor plates up to 80 metres more easily achieved. But you really max out at 80 metres in height. So the way in which I approach this is I looked at the planning controls, looked at the context of the site, and I sat down with one of our urban designers, Esther Yong, to develop some floor plates at the podium, the tower, and those upper levels. And what we determined was that up to about 60 metres in height, we had some viable floor plates. But above that height, we had, although in theory you could go higher than 60 metres, the viability of these floor plates was extremely limited. And so, for the purpose of, well, I've zoomed in. Didn't realise this was a touch screen. Oops. That's nifty, isn't it? Yeah. So what that produced was a visual envelope, and for the purpose of my advice to the tribunal in this case, I discounted this area as not a viable space for commercial office, particularly given that it was going to require a side core arrangement on this boundary here, and the ability to access those levels was going to be extremely difficult. And if you brought a central core up through the building, the usability of this space for commercial office was going to be extremely limited. In this matter, there was an expert opinion called by the Valuer General as well, and there was disagreement between myself and the other expert, and that amounted to approximately 5,000 square metres of GFA difference, which, according to Chris, was a material amount and worth objecting to. So that's really all I have for you today about town planning and its role in this objection process. Once again, thank you very much for listening, and I think there's some question time if you've got any. Thanks very much.
To get you out of here by 9 a.m. But are there any questions for any of them?
We've got one online, Andrew. It says, what rights does a tenant have to object to rates notice? I see this being relevant as landowners start to object looking for higher rating values on WGT applicable properties as they look in to increase their Civ 1 prior to rezone. That came up while Ebony was talking, so.
Is the question, what right does a tenant have to object to? Well, I suppose it depends on the term of the lease to start with, whether they're obliged to pay the rates. I don't know, do you know? Yeah. So that would be that. I've got a question. Chris, if you object to something and there is either a determination or an agreement about a revised site value, what happens in the following year? Do they take that into account, or let's go back? Because often you don't want these to be a one-year wonder. You want it to, you get to object, you want to have the benefit of it going on for a number of years.
Well, that's a good question, Andrew. It's especially with the annual rating cycle now. Previously they were every 2 years, so usually objections could sort of filter through the decision process and then be reflected in the following year's review. But now with annual valuations, unfortunately the decisions in the process is just not fast enough to be able to capture the outcome to then influence the following year. So we're finding we're continually having to object on the same issue each year, unfortunately.
Until there's a determination or resolution?
Well, until at some stage the market changes and the value just naturally changes with that. I mean, the argument is that the values are assessed every year separately with sales evidence. But when it comes to things like gross floor area in particular, which is a direct impact on the value, it can be a bit of a slow process to eventually catch up, and it's a matter of, I guess, as the advocate, and what we tend to try and do is to really try and keep on top of the matter with I guess the valuers that are preparing the valuations to take note and then factor them in into the following years. So it can drag on for a few years, unfortunately.
Other questions?
Just with all the extra cladding issues at the moment, we've actually, I think we've got over 800 buildings now with extra cladding issues. Have there been many objections to site valuation and so forth?
Well, I think that the cladding probably directly relates to not site value, because site value assumes the improvements or the buildings are not there. It's more of an impact on the capital improved value, which is the value of the land and the buildings and all combined in there. So it depends on the magnitude and the extent of the issue and how that can be directly related to impacting on the capital value of the entire building. Typically it might be strata apartments where there's individual units, which unless it's a very difficult issue to take account individually into the apartments.
Probably worth another breakfast seminar on its own.
I'm just wondering, are there any cases put forward at the moment?
Not from a rating point of view that I'm aware of.
Any other questions? Well, whilst I experience the objection process virtually every day of the week, Chris's presentation, when I stand back and look at how it all works, was very informative from my point of view. And I thought Will's presentation of how the planning, from how he provides planning advice to his clients, and then how he provides planning advice in site-specific areas was fascinating. So I'd like to please thank all three presenters for today's presentation. And as a long-standing lawyer, one thing has always confounded me, and that is what the next. This is the next breakfast seminar, is it? There we are. What do you do when you've got stuff on your property that nobody wants? how to get rid of it. That's basically it. Abandoned goods. In the good old days, you used to have to get the sheriff out there. I don't know what happens now, but do we have a date for that, Andrew?
Next Thursday.
Oh, it's Thursday next week.
Yep.
Oh, well, there you have it. Thursday next week. Really here, and you'll find out how to get rid of those couches that are out on the lawns in your suburbs. Thanks very much.